New York has some of the most tenant protective laws in the country. When it comes to landlord entry, New York's rules are enforced strictly, and the consequences for violations can be serious. Welcome to tenantscreeningbackgroundcheck.com. Here's what New York landlords need to know about right of entry. New York does not have a specific statute that sets a mandatory notice period for landlord entry in residential tenancies. Instead, reasonable notice governs, and New York courts generally treat 24 hours as the standard for what is reasonable. In New York City, additional protections apply. Landlords are required to give reasonable advance notice and may only enter for specific permitted purposes. The city's strong tenant protection framework means that entry practices are scrutinized closely. New York permits landlord entry statewide for making repairs, conducting inspections, showing the property to prospective tenants or buyers, and in genuine emergencies. Emergency entry without notice is available for immediate threats to the property or tenant safety. What sets New York apart is the seriousness with which courts treat harassment. Repeated, unauthorized entry in New York can support a claim of tenant harassment, which carries significant legal penalties, including damages, injunctive relief, and attorney's fees. New York City specifically has a tenant harassment law with substantial civil penalties. The right to quiet enjoyment is deeply embedded in New York landlord-tenant law. Landlords who use entry as a tool to pressure tenants face real legal exposure. For New York landlords, give at least 24 hours written notice, enter for legitimate purposes only, and document all entry notices carefully. If your property is in New York City, familiarize yourself with local tenant protection ordinances as well. For complete landlord resources and tenant screening tools, visit tenantscreeningbackgroundcheck.com.